Before we get started, I just have a couple of slides I just want to do as an introduction to this. Glenn and I have met a few times and continued our communication over Skype, etc., with regards to this particular overview. There's some live workshops that Glenn will be doing in Alberta and in Vancouver in February. And this is an introduction and overview for the concept of asset protection. It's kind of interesting. It was one of the first things that I was taught when I got started in this whole idea of looking into the law and how the system works and all that other good stuff, because I was effectively taught that before you do anything, you should protect your assets before you risk them. And so asset protection is one of the first things that really people should evaluate, because if you are, quote-unquote, challenging the status quo as to the way things work, there is a possibility to tick off the wrong people like the CRA, IRS, and other agencies who don't like people spreading the truth about the way things are, and then will obviously target you for that. So learning and understanding the concept of protecting your assets was a key part of it. And one of the things I remember is that the poor are taught differently than the wealthy in terms of asset protection. And we're taught that ownership is everything. You want to own your car, you want to own your home, you want to register your savings plan, etc. And it's all about, we learn to register and get our assets connected to the system, so they can track everything that we do, they can tax everything that we do, and then we're easy prey for the lawyers who, if you get sued, all of your assets are registered, and then you become easy prey for getting a hold of your assets, because they're all part of the system. And the rich learn something different. They learn the concept of own nothing but have access to everything. So what they do with their assets is that they have trusts hold everything. They own nothing personally in their personal names. They're all owned by trusts or corporations, but they use them as if they own them. And their goal is to be judgment proof, because they're potentially subject to being sued. They could lose assets, whereas if everything they have is in some type of trust protected structure, then if they get sued, the only thing at risk is that particular item that's in that trust. And this type of information Glenn is going to go into much more depth in, but these were the first principles that I learned with asset protection. And they pay much lower taxes. And this is an interesting concept I heard just a few months ago from a gentleman in the United States. He was actually a tax planner, and he said this with relationships to the income tax code in the United States, is that the tax code is effectively 20 pages or less of what is taxable, and 1,600 plus pages of tax deductions and exemptions. So from a tax planner's point of view, there's very little information about what is taxable, and a whole lot of information about tax deductions, exemptions, and structures for reducing taxes and so on. And average people, everyday people, don't learn these things. And so what we're going to be introduced to tonight from Glenn is a concept where he's been operating in a way that protects his assets through trust structures and corporate structures, etc. And so he's going to do an overview of that. So I'm looking forward to hearing the presentation, and hope everybody finds good value tonight, because it's an important topic that we just don't know enough about. So I'm just going to hand over the presentation to Glenn.
Okay. And I would just like to say at the beginning here, JD said that I protected my assets. Well, actually, I don't have any assets, so that's the situation you want to be in. So that was a little bit of a misspeak.
Good point.
But I understand what he was saying. And one of the things that we do when I do this private information share is everybody is going to have to sign a non-disclosure agreement, and the reason is that the only way that they ever find out anything about us is because we tell them. And so part of what we need to understand is we need to keep our mouth shut. And part of the strategy with these documents is that they're proprietary. They're not to be disclosed, and unless there's a court order. And once you understand, how all this works, quite frankly, it's going to be very difficult for them to get a court order. The key to any asset protection strategy is to treat people honorably. Don't go and steal money and do those kinds of things. That's going to get you mixed up in lawsuits. And treat people with honor and resolve issues. And if it's done properly, you're not going to have any problems. And then on top of that, if you keep your mouth shut. And that's probably one of the most important things you can do with any asset protection strategy is keeping your mouth shut. The guy that showed me this stuff, he told me that if he died, his wife would have to go to about 7 different attorneys and get documents from those 7 attorneys, and then she would have some idea on some of the things he was involved in. So, the point is that his wife didn't even know what he was doing. And so that gives keeping your mouth shut a whole new perspective. I can't stress the importance with anything about keeping your mouth shut. And, loose lips sink ships. Anyways, let's go ahead and start with this presentation. What we're going to discuss, a little bit of an overview of what we're going to discuss. Actually, at the private information share, we're going to breeze over some of the stuff here, and we'll talk about it more at the private information share. But what we talk about is how the contract trust is set up. They're called pure trusts, and we're going to go into that here today, what the courts are saying. There's 3 different kinds of liability that you're exposed to, how to use trust to limit that liability, and how to use statutory entities with the trust. Some people, and I don't want to mention any names, but some people have said to me, they said that they didn't have a problem with trust, but the government doesn't recognize them, and it was like they said it with a certain amount of frustration. And a lot of people don't understand the purpose and the proper way that these are supposed to be used, because that's exactly what you want. You do not want the government to recognize them. If the government doesn't recognize them, then they're not going to try and tax them. And that's exactly what you want. There was other people have said there was a story about some lady. This is quite a while ago, from the people I learned about this from, told me about this lady that had a large amount of money, and she was looking into these structures, and she took one of the documents to this attorney, and the attorney looked the paperwork over, and he says if you transfer your property into this structure, it will be gone. You will never, ever, it'll never be yours. It'll be gone forever. And she says, okay, thank you very much. And that's exactly what she wants, okay? If it's done properly, that's exactly what will happen. And so you have to understand the nature of what it is we're doing. And if it's done properly, you will not own anything, and it'll be gone, okay? But that's exactly what you want. Anyways, so let's keep moving here. This is a court case. Now this is talking about jurisdiction. And it says all subjects over which the sovereign power of the state extends are objects of taxation, but those over which it does not extend are exempt from taxation. This proposition may be pronounced as self-evidence. So the sovereignty of the state extends to everything which exists by its authority or its permission. This is a U.S. Supreme Court case, by the way. But so the point is that these structures, that's the reason they don't recognize them, because you didn't get permission from the government to set them up. You just used your common law right to set them up. And actually, other people used their common law right in this case. But the bottom line is that it exists by virtue of common law, and they don't have any authority over them. And there's lots of court cases that talk about this. The taxing power be in its nature unlimited over the subjects within its control when enable the state governments to destroy the above-mentioned rights. And that's true, okay? The power to tax is the power to destroy. And they tax their property. That's exactly what's being taxed. And if you're being taxed, it's because they think that you're their property. And with the IRS, and I think we're going to cover this a little bit later, so I won't go into it too much, but I took the IRS to the Supreme Court twice and got it to where they don't want to talk to me, and I kind of like it that way. And the whole argument all the way up to the Supreme Court is, where's the contract? I want to talk about the contract here. And they didn't want to talk about the contract. Anyways, a tax is an impost, a tribute imposed on the subject. Okay? If they're taxing you, you are subject to them. You are their slave. It's an excise, a tallage. In public law, taxation signifies a system for raising money for public purposes by compelling the payment by individuals of sums of money called taxes. In some general principles of taxation said to be the subjects of every state. If you are being taxed, you are a subject. This is Dictionary of English Law. So you've got to understand the nature of taxes. Now, a license, you know, this is another important concept of a license. A license is a contract, and it's express or implied. And so, in other words, when you pay a filing fee in a court, that is a tax. It's an excise tax, and they're giving you an implied license to proceed in their court. That's exactly what's going on. And if you go down to the bottom of this, it says an implied license is one which, though not expressly given, may be presumed from the acts of the party having the right to give it. And that's Bouvier's Law Dictionary. And again, so we're talking about a license now. And this is the requirement of the payment for such licenses is only a mode of imposing taxes. That's what licenses are for, is a way of imposing taxes. It's just another way of getting revenue. License is only a mode of enforcing the payment of the taxes. And the recognition of the power of the right of the states to tax or control or regulate any business, okay? So again, a license is only for their subjects, okay? Their slaves, their property. These are some Canadian court cases that talk about this. This is Mueller Industries versus Mueller International. This mark can support the existence of an implied license agreement. And then it goes on and it talks about its role is to gather Canadian income, report it, and pay taxes. And so, again, they're talking about the same things, okay? They're talking about licenses and taxes. It's all work together. And evidence of control by the trademark's owner can support the existence of an implied license agreement. And then it talks about Mr. Siegel is an associate of this Toronto law firm that specializes in tax law. And so again, the license has to do with the tax. This is another, this is a U.S. case. If it were true that there's talking about, we'll go down into the second paragraph here, or second sentence, is if the principles of liberty and of our Constitution forbid the raising of revenue from those who are not represented, do not these principles forbid the raising of it by duties, imposts, and excises as well as by a direct tax? Okay, so in other words, if they cannot tax you unless you're being represented, and there's Canadian court cases that talk about this as well. This is a Canadian case. No taxation but without representation. The legislature expressly and clearly authorizes the imposition of a tax by a delegated body or individual. The requirements of the principle of no taxation without representation will be met. The issue is therefore whether the principle of no taxation without representation is respected. And so the point is that the War of Independence was fought over taxation without representation. That was the big slogan in the War of Independence. And they talk about it in Canadian court cases, okay? They cannot tax you unless you're represented. And if they are taxing you, it's because they're representing you. And so what's the answer to that? You're fired. That's what the answer is. Here's another Canadian court cases. Revolutions have been fought over taxation without representation. Gee, I wonder what that one's talking about. The U.S. Revolution is what that's talking about, and the War of Independence. Here's another one. The principle of no taxation without representation is central to our conception of democracy and the rule of law. And that's King Street Investment Limited versus New Brunswick. This principle of no taxation without representation, matter of fact, it says it basically twice in that case. So you have to understand these are some basic concepts. Thank you. To understand before we start talking about trusts, and because the trusts that we're talking about, there's different kinds of trusts. There's statutory trusts and there's common law trusts, and so a statutory trust has to file a tax return, but a common law trust does not, and you have to understand the difference, and why they don't recognize a common law trust. And this is actually a definition taken from Black's Law Dictionary, 4th edition. A trust is a right of property, real or personal, held by one party for the benefit of another. And that's essentially what a trust is. That's a real basic understanding of a trust. In other words, I give away my property to be held by a trustee for the benefit of my children. That's a good example. Trusts are derived from the law of England, and they go back to Roman law. In Old England, they were called a use, and they were also a usufruct. Okay, I'm sure a lot of people have heard the terminology usufruct. Well, a usufruct is civil law. It's the right of enjoying a thing, the property of which is vested in another, and to draw from the same all a profit, utility, and advantage which it may produce, provided it be without altering the substance of the thing. And a usufruct is a type of a trust. And this is taken from the commentaries of Gaius and the rules of Ulpian, translated with notes. And that's an old Roman book that was written like around 350 AD. And here, if you look in paragraph 7, it says, well, there's a bunch of things I want to point out in this, because this is an interesting site. It says, on the other hand, we can of our own free will make land religious by conveying a corpse into a place which is our own property, provided only that the burial of the corpse devolves on us. But it has been generally held that on provincial soil, land cannot be made religious, because in such land the ownership belongs to the Roman people or the Caesar, and we are considered to have only the possession and usufruct, the use. Still, however, such a place, although it be not religious, is considered as religious, because that also is consecrated in the provinces, not by authority of the Roman people, is strictly speaking not sacred, and yet is regarded as sacred. So the point is, there's a couple things here. First of all, it's why they spell your name in all block capital letters on a headstone, okay? Because they're talking about a usufruct, okay? That's a fictitious entity, that's a trust, and that's why the name is spelled in all block capital letters on the headstone. And it also talks about here about why the state, okay, cannot be associated with any religions, okay? That's all Roman law, and that's going back to Roman law, and this is what you see going on all over the place. This is what JD talks about on privateperson.com. This is all Roman civil law, and it's all over the place, and that's what you have to understand. But the courts still recognize common law, but you have to make sure that you get it. Here's some more stuff taken from that same book, the Commentaries of Gaius and the Rules of Ulpian. It says further, some things are corporeal and some are incorporeal, okay? And it goes into the definition of what the difference is between corporeal and incorporeal. Corporeal things are those which can be touched, as a field, a man, a garment, gold, silver, and in a word, other things innumerable, okay? Something that you can touch. Incorporeal is something that cannot be touched, of those things which consist in a right as an inheritance, a usufruct, or obligations in any way contracted. None of those things can be touched, but so they're incorporeal rights, incorporeal things. And again, it's talking about a usufruct. And here's some more stuff about usufructs. It says also, since it is possible for a usufruct to be established over slaves, and other animals, we must understand that usufruct over them can be established by cession in court, even in the provinces. Now, when we said that usufruct admitted a cession in court only, we were not speaking at random, although it may be established by emancipation also, inasmuch as it may be withheld an emancipation of the property. For in such a case, the usufruct is not emancipated, although the result of it being withheld and emancipating the property is that the usufruct is left with one person and the property with another. So if you think about it, first of all, we're going to talk about emancipation in the next slide, but emancipation is enslaved, okay? And that's exactly what's going on in the courts, is they're trying to enslave you, and they're using a usufruct to do it. And so here's emancipate, to enslave, to bind, to tie. That's Black's Law Dictionary, 4th edition. And then in the U.S., everybody's heard of the Emancipation Proclamation, and that's by the act by which one who was unfree or under the power or control of another is rendered free. And then if you go on here, it says the term emancipation has been borrowed from Roman law. Okay, again, it's Roman law. That's what this is all about. This is all about Roman law. Again, they don't have authority over anything that's common law, and all of their statutes are Roman law statutes, and again, it's all in what you tell them, and again, we got to start keeping our mouth shut. There's many different kinds of trusts, or types of trusts. There's a constructive trust, there's cesticate trusts. I'm sure a lot of people have heard of cesticate trusts. There's contract trusts. Contract, another word for a contract trust, is also a pure trust, although it can vary. There's different kinds of contract trusts. Some of them are pure trusts and some of them are not. There's living trusts. There's one that's not mentioned here is an express trust. Okay, an express trust is one that says we're going to create a trust. That you're expressing, you're creating a trust. There's an implied trust. Okay, in other words, if you give some money to someone to hold for your kids, well, that's an implied trust. And whether maybe it's not even in writing, that's implied. Okay, so there's two basic categories of trusts. There's revocable and irrevocable, and I don't do anything that's revocable. Revocable is borderline statutory. Irrevocable is the only way to do it, and that makes sure that you have all the protections that you can have. And a little bit of background about myself. The first trust I ever set up was in 1992, and I've been using trusts in various ways for access protection ever since then. A friend of mine in Utah, well, actually, he lived in called the Arizona Strip, or I should say it's northwest corner of Arizona, and it's not in I can't remember, Kingman. It's not Kingman. He lives in a little town called Littlefield, Arizona, which is just a little corner of Arizona that, if you know anything about Interstate 15 in the States, it goes through about 5 miles of Arizona. It goes through Utah and then about 5 miles of Arizona, and then you're in Nevada. And he lives in this little town called Littlefield, Arizona. It's right on the edge of the Virgin River Gorge. And he had set up his own common law town. This guy was pretty sharp, and I've got all the documents. And matter of fact, he told me that this lawyer got a hold of all that stuff, and he was selling that stuff for like $10,000 a pop for anybody that was interested on how to set up your own common law town. and I'm telling you, it was really well done. He had a constable, he had courts, he had everything all set up, all of the documents for setting all that stuff up. Anyways, he's the first guy that I had heard about trusts. I was aware of trusts, but he actually gave me some trusts, and he says basically use these as a template and make up a trust. And so, you know, I did that, and these trusts were not near as good as the ones that these ones that we're doing today are, for a bunch of reasons, and we'll go into that more when I do the private information share. In the early 2000s, a friend of mine from Toronto introduced me to a guy from Georgia, and we'll call his name Bob, that had an interesting story to tell. And this story is very interesting because I have firsthand knowledge of this. In that, well, let's go into it. It says he was an articling attorney for the Colorado Attorney General's office in the 80s. And when a principal or owner of a discount house, which is really a third-party debt collector, disappeared with approximately $1 billion, the articling attorney was assigned the job of finding the money. Now, the reason I have first-hand knowledge of that is that I was involved in that. I had $1,000. They were paying. I had $1,000 invested in that discount house, and it was through my brother. And they were paying me $105 a month on that $1,000. And so I was getting like 120% a year on my $1,000 investment. And if you understand how a discount house works, they basically go to a company that has receivables, and they say, well, if we pay you for your receivables now, how much of a discount will you give us? And then we'll just go and collect the receivables ourselves. And so essentially what happens is they can usually collect the receivables anywhere between 30 and 90 days. And so we'll say, as a ballpark figure, 60 days. On average, they collect the receivables, and they get like a 30% or 20% discount. And so we'll say 20% every 60 days, and you figure you calculate that out, that's 120% a year that they're making on their money. Now, 20% times 6, yeah, that's 120% a year they're making on their money. And so it's pretty lucrative business. There was a lot of people that had a lot of money invested. There was even stories of people selling their house or mortgaging their house and putting the mortgage money in there. And it would have worked fine, except that one of the owners just up and disappeared with about $1 billion. And this articling attorney was assigned to find the money. And he said he actually found a couple million. And that's when he learned about these structures. These are extremely powerful. You have no idea. The people that showed me this stuff, they used to hold seminars before 2000. And I think I'm going to go into that here. Yeah, and I talk about that here, about how I had first-hand knowledge, and I was getting $105 a month. This articling attorney set up structures for people until the late 1990s when he sold the businesses to people in California. And they're the ones that helped me set up my structures. The people in California had a website called Financial Fortress Associates and held seminars until 9/11 happened. One of the people from FFA told me that they had seen a trust that was set up by William Penn and is still operating today. Now, I don't know if anybody knows who William Penn was. William Penn is the guy that got granted Pennsylvania by the King of England. Okay, and this trust is still operating today. If you go on the there's huge corporations in the U.S. I think most of them are trusts, because if you go and, like Fidelity Investments, you'll find no stock being traded on the stock market called Fidelity Investments. You might find a stock being traded called Fidelity Brokerage Services Company or something like that, but not Fidelity Investments. And I think it's trust. But who's to know? I mean, nobody's going to tell me. There's a story about Rockefeller. Rockefeller, some guy went to visit Rockefeller, and he was sitting on the couch visiting with Rockefeller, and he got his cat scratched him. And so then he left, and he thought, well, you know, I just got scratched by this cat. I guess I better go check it out, get it checked at the hospital. And so they gave him tetanus shots, and they did all this other stuff. And so then he had all these bills, and he thought, well, you know, I've been damaged here. I need to get some remedy here. So he sued Rockefeller, and ultimately he won. You know what he got? He got the cat. So if you understand how this stuff works, it's extremely powerful. Anyways, a friend from Ontario set up 3 of these structures for me, because if it's done properly, you cannot do it. And still management, and I manage them, and I still manage them to this day. In 2006, I was working for U.S. Airways Engineering Department in Phoenix. The IRS had essentially garnished my pay and was taking about 25%. I filed a lawsuit and criminal complaints and a commercial lien. During this time, I got a job working for Eaton Corporation in Fort Worth, Texas. And in that job, well, we'll go on here. Because of the IRS issues, I did not want to leave U.S. Airways and then have to start a battle all over again with Eaton. The people from California set up the trust and the limited liability company. The people in California offered to set up banking, and they offered to provide signed checks and a debit card, but I declined, quite frankly. I'm a kind of in-your-face sort of guy, so I went and did all that stuff myself. Anyways, I've been doing aerospace engineering for all sorts of companies, including classified military programs through the limited liability company ever since. The only issue I ever had with the IRS is when I used the wrong form. And they went and threatened like a $1,200 fine, and so I went and sent them the proper form, and that was the end of it. Never heard from them again. A friend from Ontario is still managing trusts and limited partnerships in Ontario and elsewhere in Canada since then. The only issues the people of Ontario had was with the bank accounts. And the reason they had problems with the bank accounts is that ideally, okay, remember the friends in California offered to set up the bank account, offered to set up give me a debit card and a bunch of signed checks and all of that stuff. And so they could have done that, and they were doing that in Ontario. The problem in Canada is there's, what, 5 banks? And so there's a limited number of banks. They actually had a bank that actually just arbitrarily closed down 20 of their bank accounts because they were all under the name of this trustee. And so the bank started balking at setting them up under this trustee or under any one person having 20 bank accounts. And so with the ones that we're going to do, the manager is going to have to set up the bank accounts. And so ideally, if the trustee sets up the bank account, then the manager is not going to be, his name is not going to be on anything that's public. And so it's even more powerful then. But we're not going to be able to do it that way, but that still doesn't mean that it's not going to be powerful, because it'll still be pretty good. I haven't had any problems. Anyways, here's some court cases that talk about it. The phrase pure trust is another name for a contract trust, and this is a U.S. case. A pure trust is a contractual relationship in trust form, okay? So it's a contract trust. A pure trust is not illegal if formed for the express purpose of avoiding taxation. A pure trust is not illegal. It basically says the same thing. Dignity of contract cannot be set aside because a tax benefit results either by design or accident. An association does not become illegal simply because another very like it is taxed. It is established by legal precedent that pure trusts are lawful, valid business organizations. And these are pure trusts. They're contract trusts. A trust or trust estate is a legal entity for almost all purposes, as are common law trusts. Okay, so a pure trust is established by contract, and any law or procedure in its operation denying or obstructing contract rights impairs contractual obligation and is therefore violative of the U.S. Constitution, in this case for U.S. But again, the same thing applies in Canada. It's all your common law right to make contracts. A pure trust organization consists of the U.S. constitutional right to contract, which cannot be abridged. The agreement, when executed, becomes a federal organization and not under the laws passed by the several legislatures. A pure trust is not subject to legislative control. The courts holds that the trust relationship comes into the realm of equity, and we're going to talk about that in a minute, based upon the common law, and is not subject to legislative restrictions, as are corporations or other organizations created by legislative authority. Remember, we talked about how the government can tax its property, okay? And this court case is saying that a trust is not the property of the government. The basis for the common law trust in this connection is not that such organizations are creatures of common law as distinguished from equity, but they are created under the common law of contracts and do not depend on any statute. It is free from, if it is free from control by certificate holders, then it is a pure trust. Okay, so that's one of the criterias that you have to have a valid pure trust, is that a pure trust has, instead of having beneficiaries, it's got certificate holders, and the certificate holders cannot have any control in the trust. Fair market value is determined by property received by the taxpayer and not the fair market value of the property transferred by the taxpayer to the trust. Certificates are personal property and convey no interest in the trust property. I mean, it's all got to be done arm's length. Certificates in exchange are not taxable until a realized gain has occurred. Even bad bargains and genuine business transactions do not result in taxable gifts. Certificates are without determinable fair market value. No gain or loss is recognized until the cost or other basis of the property disposed of has been recovered. And that's the Master Tax Guide. The important concept here is that when you exchange property into the trust, if it's done properly, then you get a certificate. Now, as long as when you exchange it back out of the trust, if there's a loss or a gain, then there's going to be a taxable event to you. There's nothing ever to the trust. The trust never has a tax issue. And I can tell you the reason why, think about it, is because the trust is an open transaction. In other words, what I do is I give, like, this computer, okay, to this trustee, to Joe Blow, this trustee, and for my kids. So he holds it for my kids. But my kids don't get it till 30 years from now. And so who knows what it's going to be worth in 30 years. And until it comes out of that trust, they cannot make an assessment of what it's worth. And so there's no taxable, nothing that can be taxed, because it's an open transaction. Until my kids get it in their hot little hands, that the transaction is completed, then it's an open transaction. And so there's no possible way of determining what it's worth. Exchange is the giving of one thing for another in kind, and excluding money as a basis of measure. And that's why the certificates have used. Certificates are not chattels, but are evidences of intangible rights. In other words, and one of the things that is done is you might, in a trust, you'll exchange a table, a kitchen table, into the trust, and you'll get one certificate. And then the next day, you might exchange your house, okay, into the trust, and you'll get one certificate. And you do that on purpose, because then who's to say what those certificates are worth? There's no way of possibly saying what those certificates are worth, because here one day you exchange the kitchen table, and the next day you exchange the house. And so there's no way of determining what they're worth. There's no value, and that's important. The trustees of a trust have all the power necessary to carry out their obligations, which they assume, and their books and records are not subject to review or subpoena. Okay, again, this is extremely important. In other words, a subpoena is, they cannot subpoena that kind of stuff. They have to get a court order, and it's not easy to get a court order. And the second citation basically says the same thing. The two main ways to pierce a trust is by fraudulent conveyance and commingling of funds. And this is very important, and you need to make sure that you understand what these are, and how to make sure that they can't be pierced. Fraudulent conveyance. This is taken from Wikipedia. Evidence, badges of fraud. Evidence of actual intent is rarely available to a creditor, for it would require proof of someone's inner thoughts. Because of that, creditors often have to rely on circumstantial evidence of fraud. To prove actual intent, the courts have developed badges of fraud, which, while not conclusive, are considered by the courts as circumstantial evidence of fraud. Now, these are some of the badges of fraud. Okay, becoming insolvent because of the transfer. Okay, lack of inadequacy of consideration. Family or insider relationship among parties. Okay, so these trusts cannot be set up by you or any relation, relative at all. Okay, and the lack of inadequacy of consideration. That's why you do a certificate, and also the same thing, becoming insolvent. That defeats that. The retention or possession, benefits, or use of the property in question. Okay, so if you transfer your house into a structure, then you're going to have to sign a lease agreement, and you're going to have to pay rent, and you're going to have to show that rent has been getting paid, etc. The existence or the threat of litigation. In other words, if you're under attack, okay, that makes it difficult. These procedures are preemptive. Okay, if you're being sued or you're under attack by the IRS or CRA, then it's too late. Okay, that's not to say that you can't do this and it won't work, but it becomes very difficult, and you better have your ducks in a row, or they're going to pierce it. The financial situation of the debtor at the time of the transfer or after the transfer. And so these are all things that the courts use as badges of fraud, and you need to keep this in mind. Some more badges of fraud. The existence or accumulative effect of a series of transactions after the onset of the debtor's financial difficulties. So if you're in debt and you start transferring assets away, well, that's a problem. And a good lawyer, you know, might be able to find that stuff. You need to be aware of that. The general chronology of events, the secrecy of the transaction in question, deviation from the usual method or course of business. So the important thing to understand is a trust is a preemptive measure. The longer the trust exists, the more powerful it becomes. After 4 years, it is almost impossible for anyone to claim fraudulent conveyance. The only way they will find out anything about the trust is if you tell them, and that's why we need to keep our mouth shut. And the only reason anyone will be asking about the trust is if someone feels unfairly treated. So we need to treat people honorably and fairly. And you know, that goes back to you know, the golden rule: treat other people the way you want to be treated. So another way that these trusts can be, or any trust can be pierced, is with commingling of funds. And the easiest way is to prove commingling of funds. Commingling of funds is when you mix your personal money with the trust money. And so you got to have your I's dotted. You got to show that everything is done. If you have a mortgage, I should say a rent payment on the house, well, you're making that payment, and that kind of thing. Now the trust, because you're the manager, you can have an arrangement that the trust is going to pay you to manage the trust. You know, that's a separate issue. And you know, again, there's stuff that I do that I'm not going to talk on any webinar because again, it comes down to keeping your mouth shut about what you're doing. It's like that lawyer friend of mine that started doing this. You know, he said that his wife would have to go to about 7 different lawyers before she started getting an idea on some of the stuff he was involved in. And so, you know, again, it's about keeping your mouth shut. So what we're going to discuss when we do the actual private information share is we're going to talk about how a contract trust is set up and the actual mechanics of it. We're going to talk about the 3 different kinds of liability that you're exposed to and how you can use a structure, a trust, to limit that liability. And obviously, if the trust is not recognized, which is exactly what you want, then how do you get a bank account for it? You know, there's actually, if you do a search, you go to Canley and do a search for pure trust. There's one of the first. There's not too many hits that you'll come up with. There's like about 5, and one of the first ones is somebody in BC back, you know, I don't know, I think it was in the 90s that had they tried to get a bank account. Matter of fact, I think it was with Royal Bank. I can't remember, but they tried to get a bank account for this trust, and they'd done some major mistakes. Okay, first of all, they went and showed the trust documents. The trust was domiciled in New Mexico. It was a pure trust. The court case doesn't dispute the validity of any pure trust, and there's nothing in there about any validity of any pure trust. But what happened is this guy had about $500,000, and so he went and gave it to this trustee to manage for him, and they went and set up a bank account in BC. They went in the name of the trust, and then they went and gave the bank the trust documents so they could look at them, and which is a major mistake. It's nobody's business what's in those trust documents. They're all proprietary, and so first of all they gave it to the bank to look at, and so then they deposited the money, and after a month or two, the bank got cold feet, and they decided that they didn't like these trust documents, so they closed the bank account, and they went and took the money and transferred it to the court and let the court decide whose money it was, and that's exactly what happened. And so that's how this court case came about, and the court ultimately just gave it back to the guy that it was like $497,000 or something like that. Anyways, the point is that's why you set up, and we're going to talk about that when we do the private information share, you set up a statutory entity, and it is partially owned by the trust. As a matter of fact, it's the majority owner is the trust, and then there's a minority owner. It's a partnership. It's set up as a partnership, and we'll talk about that when we do the private information share. So this is basically to give you a little bit of an inkling of what we're going to talk about when we do the private information share. If you want to set up a private information share in your location, you're welcome to contact me. And we have a couple set up already. There's what will also be available at additional cost is trust document templates, limited partnership articles of organization templates, operating agreement templates, and there'll be court citations, some of the ones that we talked about today, and there'll be other ones. There'll be a manual that provides instructions on how you can set up your own structures. There'll be several scenarios where trusts can be used and how to limit the liability. There'll be dozens of minutes templates for trustees to sign covering numerous scenarios, exchanging property into the trust with the instructions. There'll also be, if you want, and I'll be available to prepare the documents for you, but you can do them yourself if you want. If you prepare, if I prepare them, well, let's see. If I prepare your documents, it comes with coaching webinars. If you prepare them, it comes with one webinar. I'm available to set up limited partnerships, but the cost is dependent on statutory fees and costs in your jurisdiction. I know in BC it's $275 to set up a limited partnership. I'm not sure about the price in Alberta or elsewhere. The trust will need an annual meeting of the Board of Trustees. These are ongoing costs, and so the usual cost is set by the trustee, but usually it's like $200, and that's basically a letter saying Joe Blow, who's the manager, has been doing a great job, and we're going to hire him for another year. The limited partnership will need annual renewal fees determined by statute, and usually that's a couple $100, but that's set by the general partner. If a tax return is required, the general partner will need to sign it. In the U.S., a limited liability company has to file a tax return, but at the same time, it says right on the tax on the form, it's the 1065. It says right on the form, it says, is one of the partners a disregarded entity? And that's exactly what a trust is. It's a disregarded entity. And so you tell them, yes, it is. Now, under the regulations, and it says that you're supposed to ask for a tax ID number. So when you file for that a disregarded entity, you put down requested. And so then you're complying with the regulations. You asked for it, but you didn't get it. And so I've been doing this for since 2007, and I've had no problems at all. There's a live private information shares scheduled for in Grand Prairie on the Sunday the 2nd of February, in Edmonton on the 8th of February, and in Vancouver on the 15th of February. And they're all listed on the privateperson.com blog, and that's all available for there. Anybody wants to set up a private information share, you can contact me at my email address or through JD on privateperson.com. I suppose that pretty well covers it all. It looks like we've used up most of that hour. Does anybody have any questions? My email is it's on the front page right now. It's engineerwin@gmail.com.
All right, and all of the contact information is also on privateperson.com website, where the webinar information, and also you can register for or enroll for any of these private information shares on the website as well. So you can email directly to Glenn, or you can go online to the web page on the website, and I'll just grab it here and put the link into the chat box so everybody can click on the link in the chat box. There we go. So if you look at your chat bar, let's see. Oops. There we go. There's the link to the web page, which has the information on what's going to be covered in the workshop, the live workshop, and then how to enroll for the different locations. And with regards to questions, there was one question: is can one exchange a property into a trust when there is a mortgage on it?
I know for sure you can do it in the U.S. There's in every state there's a Garn-St. Germain Act. I'm not sure about Canada. I need to look into that.
Okay, and is there going to be Canadian-specific content and legal references?
Well, yes. Yeah, well, I thought I provided some here, but it's all common law. And even if you couldn't transfer the house into the trust, you could certainly use the trust to put another mortgage on the house. There's a lot of ways you can do that.
Okay, I just put a second link into the chat bar. It's one is a blog post talking about the webinar, and the second one is the actual page for registration. So that's what the second link is in the chat bar. How do you sell something that's in a trust, like a home?
Well, you don't sell it. First of all, the trust will sell it, and it'll be treated like any other commercial transaction.
Okay, so if you put a house into a trust and then you want to sell it, the trust is actually the seller of the house, and what happens to the funds? How does the funds get transferred to who?
The funds will go into the limited partnership's bank account,
and then that can be paid out.
And then what will happen is it'll stay in the. That's the nice thing about a limited partnership is that the limited partnership basically holds the funds for the trust. The trust doesn't have a bank account, and so you know the money will just stay in the limited partnership's bank account. And the limited partnership doesn't ever have to do a distribution, so the money can. Like in the States especially, there's actually court cases that talk about it where with the limited liability company in the States, if you sue, that's why you see all these people that have these limited liability companies, because if you sue a limited liability company, all you really win is tax liability. And so if you get a $100,000 judgment against the limited liability company, then what they do is, as part of the tax return, they show that you have $100,000 worth of income, but they never have to give you the $100,000. I mean, there's nothing saying that they have to ever do a distribution. The money just stays in the bank account, and you get that $100,000 worth of tax liability. So then you have to pay taxes on that $100,000, but you never necessarily get it until they do a distribution. And what they do when they do a distribution is if they have a X amount of profit, then they have to distribute to all of the owners. And you know, so in other words, it's pretty slick actually. That's why you see all these people have these limited liability companies in the States that are very popular, and it's pretty slick. But so it would work the same way in Canada. I need to see if I can find some court cases that talk about it. But it's basically the same idea. It's all it limits liability, and it's a partnership. In BC, the Partnership Act even talks about trustees of a trust being one of the partners. So it's all, you know, I guarantee you that the reason they went and put that Partnership Act in place is because they're doing exactly what we're doing. And you know, that's what's going on.
Well, like I said at the beginning, this is what the wealthy do. This is how they structure, and they just, you know, don't want us using it because they want us to be more susceptible to taxation and seizure and everything else. So how many people do you want to have for a private information share before you would travel somewhere? Like I got some people in Toronto who want to know if you're going to go there and how many people you'd need to make it worthwhile.
Well, obviously, it's got to be enough to pay for the airfare. I mean, you're talking to travel to Toronto. You're talking probably, you know. I mean, the actual private information share isn't that long. It's maybe a half a day, but I got to have airfare going back and forth, and hotel, and you know, etc. You know, you're talking. You know, I'd have to
Leave it at that. And if anybody from Toronto or any other city wants to talk to you about it, they can communicate with you directly and you guys can work it out, right?
Right. Yeah, that's fine.
Do it based on numbers. So that's good.
Yeah, right.
Okay. Is a bank account in a Canadian bank or any bank considered as a trust, and the bank would be the trustee of the account?
No, no, absolutely not. The trust is not going to have a bank account, and that's one of the most important things. Is that that's why you set up the statutory entity. The trust is not going to have a tax ID number of any sort, and it's not it's not even going to. In what they're doing in Ontario is quite frankly, the limited partnership doesn't even file taxes in Ontario. What they do is the partners that have the issues file their own taxes, okay? And obviously the trust doesn't have a tax ID number, the trust is not recognized, and the trust doesn't file taxes. The other partner, which is a statutory entity, does file taxes. And so whatever loss or profit comes into the partnership is going to have to be declared for the other partner. But the trust is disregarded.
All right. And does any of this trust have to do with the trust law, like what Dean Clifford is talking about, i.e. tickets and such? Just very quickly, no, it doesn't. It's about if you have assets like cars and houses and you want to protect them, then you would put them into a trust structure, which is a very different thing than what the trust stuff that Dean talks about. This is about assets.
Yeah, I'm not sure what Dean Trust talks about. I think he's talking about Sesticate trusts, and that's different. This is not a Sesticate trust.
Vehicles can be put into trusts too, right?
Well, actually, again, the trust isn't recognized, and so you can put a vehicle in trust, but the way it's going to be registered and the way the house is going to be registered is it's going to be registered under the name of the trustee. In other words, ABC Company, trustee for XYZ Trust. That's how it will show in the registration or in land titles. And so it'll be registered under the name of the trustee. That's the only way you can do it. In the States, technically, that's actually the proper way of doing it. And in the States, it's easy to register a house or a vehicle under the name of a trust. And people do it all the time. But technically, it should be done exactly how they're wanting to do it in Canada. So Canada is more technically correct, actually.
All right, so we're at 8 o'clock. We had scheduled for an hour. We can keep on going. There's a bunch of questions coming in, so if anybody has to run, feel free, but we're going to continue going to doing question and answer as long as you can hang on, Glenn.
Yeah, well, can I step away for a couple minutes?
Sure, I'll answer what I can, and you get back when you can, all right? All right, I'll see what questions are here that I can answer. One question, aren't commercial transactions taxed at a higher rate? Well, these aren't commercial transactions. I'm not fully up to speed with regards to how it all works, but ultimately the transactions, any of them that come out of this system are taxed at a very low rate. So again, I'm not quite sure how that happens, but Glenn has clearly described to me that that's what it is. It creates a low tax structure. Is this just for businesses? No, it's not just for businesses. Any individual can do this in order to create a structure to protect your personal property, or what, like at the beginning, Glenn said, no, he doesn't have any assets. Well, he doesn't have any assets because he got them all protected through structures like this. So yes, anybody in privately, their own house, their own car, can use this in order to create structures. This is, again, what the wealthy people do for their personal property, personal estates. They're all done through structures like this. Let's see. Canadian court cases, yes. But Glenn actually lives in Canada and in the States. He's very well informed on Canadian court cases, and that's definitely a part of what he's going to be providing to people for it. Tax minimization for employees, I don't believe so. This is a different structure than that. And there was one case of an individual I knew years ago who was a real estate agent and had CRA issues where they were coming after her, and she basically had CRA go away when they couldn't access her. She had like 3 or 4 homes that were protected through a corporations and trust structure, and they didn't access them because they were protected, and that's definitely what you want to do. So Glenn's back. I'm going to ask you another question here. What are you giving to the banks to open an account? It's not under the trust that it's opening the account. Who's opening the account, and what do you give them for ID?
Well, you go ahead and give them your ID. I mean, but it's under, you set it up as the manager of the limited partnership.
Right. So the manager setting up an account for the so in the partnership's name.
Right.
Right. Okay. All right.
And the limited partnership will be a statutory entity, so it'll be registered. You'll have documentation from the province.
Banks normally scrutinize commercial entities for history, etc. Does this apply here?
Well, I mean, it's not going to have much history because we basically just set it up, right?
People are setting up new businesses and new limited partnerships all the time, so yeah, it shouldn't be a problem. Can I put my commissions from business into an LP? Can I do it as work for funding the trust?
If you want, I mean, how would you put this? The way I work, okay, is that if I get a contract, it's all on a contract basis, and the contract is with the limited partnership. And so if the money being paid out is in your name, then you need to talk to whoever's paying the money and ask them, if they have a problem with paying it out to this limited partnership. And that would be the way I'd approach it. If they do, then that's going to make it difficult. It's got to be arm's length, okay? If a paycheck coming to your name is going into that limited partnership, then that's commingling of funds, and that's a problem. You got to maintain that arm's length. If you
you're hiring out the limited partnership.
Exactly. You have a compensation for labor contract with a limited partnership, and ideally, it's even better if you have a foreign structure, because then that gets really difficult to find out any information about. For example, my compensation for labor contract is with a trust called Northeastern Holdings, which is a trust that's domiciled in Canada. And but I do aerospace engineering consulting under a limited liability company called American Engineering Services, and so but American Engineering Services has a contract with Northeastern Holdings, and so so what that does is that makes it international. My compensation is international. The minute I go across the border, everything is tax deductible. It's all traveling, and until I come back across the border, and so. It's all on how you arrange it. Use your imagination.
It's part of where having the support after getting set up will help people understand how to actually operate it and do, quote unquote, do business day to day with it.
Yeah, sure. Yeah, I mean, I'll be happy to help you out that way. But there's going to be a lot of stuff that I'm not going to put on webinars. I'll tell you privately. It's not, some of the stuff is stuff that I'm not going to put on webinars. It's all in how you arrange your affairs. It's use your imagination. But I'll be happy to tell you privately, some of the tactics that you can use that make it difficult for anybody to find out anything. And again, we need to keep our mouth shut.
That was one of my questions to you. Okay, so this gets set up for me, and how do I operate it day to day? And that you'll be helping with guiding that. And some of the written materials you provide give that with examples, correct?
Yeah. Right.
Yeah. Okay. So
yeah, well, the book actually is probably the most important thing, the manual. But again, it's a matter of starting to think outside the box and think of ways that you can do things. For example, when you start operating internationally, there's a reason why these big corporations operate internationally, because it's very difficult to find out information internationally. It's extremely difficult. You ever tried to sue a foreign corporation? It's like, that's the reason these cruise ships and stuff like that, they go and set up these corporations in all of these foreign countries, and it's just about impossible to try and sue them. These people turn up missing on these cruise ships, and the remedies, it's almost impossible to get a remedy from them. And the only thing you can do is vote with your feet and quit going on cruises. I mean, really, it's extremely difficult to get a remedy from these cruise ships. And when you start operating in the international arena, it's very powerful.
Okay, and how long does it take to set up, after, say you have the information share and somebody wants to proceed with it, about how long does it take to become operational?
Well, again, that gets into stuff that we talk about when we do the actual private information share.
But it's not a real long time. You could be, up in a few months or so.
Oh yeah, for sure. Oh yeah, or less. Yeah, a month or two.
Doesn't include anything or have anything to do with UCC, does it?
No, I don't talk about UCC at all. I mean, UCC is commercial. That's law merchant. I stay away from that, quite frankly.
It's not the trust you're going in to set up in the bank account. It's the LP, right?
No, we set up the structures. Again, that's stuff that we talk about when we do the private information share.
Okay.
But I will say that it's basically, you're going to need some structures. Some of them are statutory and some of them are common law. Let me put it that way.
All right. And have you been? Somebody says they've been looking to set up trust in Delaware. Are you aware of any advantages or not?
Actually, I've got an address in Delaware. If you want to set up a trust there, it doesn't matter where you set up the trust, because the trusts are all disregarded entities. Now, where you set up the limited partnership or the limited liability company, yes, that wouldn't matter. But I wouldn't set it up in Arizona. I actually have a limited liability company set up in Arizona, and it's the problem with Arizona is you can go on the Arizona Department of Commerce website and you can pull up all sorts of information about any company that's set up in Arizona. Delaware is good because the limited liability companies in Delaware they're difficult to get information about, not impossible. Nevada is another good place to set them up, but the limited liability company that I manage is domiciled in Washington State, and there are certain advantages there too. The bottom line is that really tax advantages, it doesn't matter, okay, as far as tax advantages are concerned, because a limited partnership or a limited liability company are considered a pass-through entity. Okay, all they do is report. They don't pay anything. They never pay anything. It's the partners that pay, and the trust is not a statutory entity, so it doesn't pay. The other partner is a statutory entity, and so whatever profit or loss that the partnership realizes would be taxable, for the other partner in the proportion that they own. But again, those are all things that are talked about in the private information share.
We got somebody here, obviously in Quebec, asking about any differences with regards to the civil code in Quebec and transferring things into a trust in Quebec. Is there any differences dealing with Quebec?
Well, they like to say that Quebec is under Roman civil law, but common law is in Quebec too.
It's definitely mixed.
What's that?
It's definitely a mix. They have access to the common law, yes.
Yes, absolutely. So, you have the right to make contracts in Quebec. The civil code, applies, trusts again are common law, and they would still apply in Quebec. you know, the partnership acts, if you go in the various provinces, I bet you they're very similar in every province.
Okay, and there's some questions here about more information on transferring a house and the paperwork, and that's what the information share is for, is to get more into depth in you know, the technical questions. So we'll leave those for the information share. And the IRS keeps coming after me, so how do I protect my earnings also with an airline company?
Okay, so that must be this must be someone that's in the States, I guess. Again, if you're in a position that you're a quote unquote employee, there's nothing that a trust can do to help you. I mean, a trust can help protect your assets, so there's nothing for the IRS to take, or CRA, whoever it is. If you don't own it, there's nothing they can do. It's completely separate. But again, like in the U.S., they don't do these lifestyle assessments that CRA likes to do. So you know, you're going to have to deal with it. If you're in the position of being a quote unquote employee, I was in that position, and the IRS was stealing my money, and that's the reason I sued them and took them to the Supreme Court twice. And now they don't want to talk to me, and I kind of like it that way. And sorry?
Key things about your entire process that I really respect is that you take these guys to task. You actually go after them and sue them for what they're doing. And a lot of people get attacked and then they don't do anything in return, and therefore, you know, they get rolled over and beat up. And you really do have to stand up and take these guys to task with suits and so on. So
absolutely. I mean, there's a principle of law called laches, which is basically it's being asleep on your rights. If you don't assert your rights, you lose them, and the courts won't respect you. If you assert your rights, then the courts respect you a lot more. And a good example is the current battle that I have going on with customs. You know, the courts. I mean, you know, their whole tone, everything is completely different than with anybody else that I've seen that have had to deal with these kinds of issues, because I'm asserting my rights, and you know, if you don't assert your rights, you lose them. That's really what it comes down to. Principle of laches.
yeah. Are all Canadian corporations limited liability? Now, you're talking about a limited partnership, which is different than a corporation, right?
It's a type of a corporation. It's a fictitious statutory entity. I mean, so it's a type of a corporation.
It's not the type people normally think of. It's a specific type of corporation.
No, yeah, right. It's a partnership. It's set up as a partnership.
Okay, how much are the fees for the documentation manuals and DVDs, or the training and stuff? You'll go over that, not right now, but at the information share. Is that correct?
Yeah, I mean, basically, I mean, you're going to have to pay to go to the information share, and if you want the paperwork and stuff, I mean, basically, as it currently stands, for a couple $100, you can walk away with everything you need to know to do it yourself.
Hundreds of dollars, and most people that I've heard teaching trust type of stuff are in the $5,000, $6,000, $7,000 range. So it's nothing like that. It's very reasonably priced. And again, that was one of the things that impressed me with what he was doing, how he's doing. He's making it very affordable. So if you're not absolutely broke, it's going to be very affordable for you. If you have any assets to protect, it's going to be a great investment, I believe. So. What about setting up in Nevada, Belize, in terms of stuff?
If you want to set up, you know, quite frankly, I wouldn't do Belize. I wouldn't do anything out of U.S. or Canada, quite frankly. I'm a kind of in-your-face sort of guy, and my attitude is why go to all the trouble of going to some foreign country when you can have it right here, right in front of their nose, and they can't do anything about it. I'm a kind of in-your-face sort of guy. It comes down to they can't see the forest for the trees.
And Paul, you've got quite an involved question here. I'm not going to ask it. If you want to send it in email format, then that would probably be the best way to answer that one. Um, here's here's the bottom line question: do you guarantee that this structure will work? Hey, any structure doesn't matter what it is only as good as the person operating it. And as Glenn has said over and over, if you can keep your mouth shut, because saying I've been using for years is private, private, private. What part of private don't you understand? And most people have no clue about how to keep their private affairs private. And that's the whole basic principles. We have the right to privacy, the right to private contract, et cetera, et cetera, et cetera. Yet we don't operate in that manner. Therefore, they invade. So um, I know Glenn has been using this structure for many years, has dealt with the IRS directly and a challenge with it and so on. The rich use these types of structures all the time. It is the way their world works. But like anything else, if you don't operate it correctly or you do things wrong, then it probably won't work for you if you have any challenges. Is that a good answer, Glenn?
Yeah, it's perfect.
Okay.
Thank you for answering.
Yeah. Yeah, there are no guarantees, man. It's like everybody wants a guarantee in terms of the magic bullet. I mean, dealing with people with detaxing and everything else over the years is like, you guarantee this works? Well, heck no, everything's in testing mode, and most people don't do it right. So it's like,
If the key is to understand it and use it properly, and you know, again, the trusts are not recognized, and so you cannot register a house or a car. I've heard of people complain that you can't put a house or a car in it. Well, yes, you're right, but that's exactly what you want, and the way you do it is how you register it. In other words, you register it under the name of the trustee. The trustee is a fictitious entity. That's the ideal way, is to have some company that is the trustee, and so then it's ABC Company Trustee for XYZ Trust, and then you can register it. And as far as personal property, like your furniture and that stuff, yeah, you can put that under the trust. All you do is make up some labels, property of ABC Trust, and that's it. And I've taken stuff across the border like that, and they have no problem. They know what that's all about.
yeah, well, I know this stuff works. I've known people being successful with it personally. I know you've had success and been operating a long time. I haven't understood it in the past. I haven't had the assets necessary to protect it, and I know this is the way the rich operate it, and it's a matter of just figuring it up and following somebody. And I think it's great that you're setting it up so that you will help people get started. Because like anything new, it can be complex to understand. So if you can, be guided, that's I think the best way to do it. Um, and yeah, people get in trouble when they promote the wrong things or try the wrong things. But very often the people who are getting into trouble are the ones who aren't doing it correctly because they didn't study it well enough to understand it properly, and they're using it as a quick avoid or get out of jail free card. And that's not the way it works. As some of the things that Glenn has mentioned here in terms of operation, there is some knowledge that's required to operate this and to figure out how to run on day to day. And that was my first questions to him, and I would hope it would be everybody else's first questions to them is, okay, I'm setting up this structure. Now, how do I operate it correctly on a day-to-day basis so that I make sure that I operate it correctly and don't cause myself any problems? And when I want to transfer, to make sure I transfer correctly and so on and so forth. And it does take effort. It does take, thought process and care to learn how to do it. So it's going to be more effort. This is the other thing is people go, I want to, pay less tax. I want to do all these other things that I want to do to be free. Well, guess what? That all requires more effort and more knowledge than the convenience of being a taxpayer and a slave to the system. So there is work and effort required in order to be free in today's world because the system is set up to not let you be free. And so that is a key thing is don't go into this expecting it to be no effort. Expect to go in to get the materials from Glenn, and if you want help to set it up, get help to set it up, and then study and be a good student to actually, use it correctly. And Glenn's making himself available for follow-up. And if you want to get in contact with Glenn, his email's on the web page. It's also on the screen right now for you, and it's also in the chat box. So if any follow-up questions you have for Glenn, feel free to contact him, and I'm sure he'll be happy to get back to you. In the meantime, Glenn, I'm just going to take the presenter back here. Call that a wrap. And again, any questions, you can email me at info@private-person.com or Glenn, email there. And yeah, thanks very much, Glenn. Appreciate it. Like I said, this asset protection stuff was the first thing I got taught. And I think it's an important step for people who are looking at, moving down these roads to make sure that they're structured properly to protect themselves. So I'm glad somebody knows how to do it, and somebody has done it, and somebody has the Canadian information, because a lot of people, have only heard about the U.S. stuff. So it's nice to have somebody with Canadian stuff as well.
Well, and I would just like to say that this was introduced to me in Canada. Okay, I found out about it after in the U.S. But the people that are doing it in Canada are still doing it, and but there just doesn't seem to be very much interest, and so they're not doing it very much, and so they don't even mind me doing this, quite frankly.
Yeah, well, like I said, the average everyday folk are trained to be totally in the system with easy access to the assets, so they can be financially raped in every way possible, and most people aren't willing to step out of that box. So good on you if you're looking at this, and good luck with the learning process. So thanks very much, Glenn. I'll look forward to seeing you in Vancouver in a couple of weeks. And if anybody has any questions, email Glenn. Email info@private-person.com. All right.
All right. Thank you.
Great. Everybody have a great week, and we'll talk to you sometime soon. Take care, everyone.
Thanks. You too.